Greetings to the Honorable Bench. The counsels on behalf of petitioners please this court. The present matter lies before this court under Article 32 and Article 159A Clause 1 for its judicial review over the actions undertaken by the Union Government with respect to Guardia. If the bench, the counsel seeks permission to address the bench as your lordship. Much obliged, your lordship. If the bench is clear with the facts of the present case, the counsel seeks permission to proceed with the arguments of first issue. Much obliged, your lordship. Your lordship, the present case arises after Union Government took several actions with respect to Guardia. Guardia became a part of Indiana through Treaty of Magna, in which it was specifically mentioned that it would be governed by the will and consent of its people. Subsequently, under the garb of after the demands of people, it was termed as a state under Article 371 AA. Under the garb of several circumstances, the Union Government passed an ordinance repealing the requirement for the Lieutenant Governor to abide by the aid and advice of Council of Ministers. This was followed by the imposition of an emergency under Article 352, during which a reorganization order was passed by the Parliament to abrogate the special status of Guardia. When all these great petitions were pending before this court, Parliament passed 107th Constitutional Amendment Act to alter the jurisdiction of this court. Council 1 would be dealing with the first and second issue, and co-council would be dealing with the third and fourth issue. Much obliged, Your Lordship. In the first issue, the council submits that the jurisdiction of this court cannot be altered during the proceedings of an ongoing case. The submission of the council would be based on a threefold argument. Firstly, 107th Constitutional Amendment Act is in the form of a legislative judgment. If your lordship can refer to page 17, paragraph 5 of the written submission from petitioner side. In the present case, your lordship, when several actions of Union Government were challenged before the Supreme Court, the question revolved around Treaty of Magna. Article 363 prescribed a bar upon the jurisdiction of this court with respect to the matters arising out of treaties, agreements, covenants which were signed before the commencement of this constitution. However, it was held in the previous case that the applicability or non-applicability of Article 363 in any case has to be decided by the court. When a plea is raised by any of the party, it has to be decided by the court itself. And in the present case, this essential judicial power of the Supreme Court was taken by the Parliament. Parliament on its own judgment decided the applicability of Article 363 in the present case and enacted 107th Constitutional Amendment Act in an arbitrary manner. Your Lordship, it is humbly submitted that even if the 107th Constitutional Amendment Act facilitates the power of judicial review, it seizes one of the essential judicial functions of this court with respect to the decision of deciding the applicability of Article 363. In the second fold of argument, it is humbly submitted that the 107th Constitutional Amendment Act violates the procedural limitations of Article 363.
Hold on, Council. You started with the judicial review. This court would like to know your understanding about the judicial review. It's a major point in this matter.
Your Lordship, the power of judicial review has been enshrined as one of the basic features of the Constitution. It is provided under various articles of the Constitution, under Article 13, Article 32, and Article 137 of the Constitution. The power of judicial review can be exercised by this court with respect to any of the legislative or executive actions undertaken by the government, including the constitutional amendments which are exercised under the constituent power of the Parliament.
There are certain restraints to the exercise of their power. There
Indeed,
are certain restraints, judicial review. There are certain restraints where you can exercise. The court cannot exercise on this like that.
Your Lordship, the Council agrees with the fact that there is a bar upon the power of judicial review in some cases. However, in the present case, the power of judicial review is not barred because the bar of Article 363 is not applicable. In the previous case itself, it was held that the bar of Article 363 is not applicable when the court has to decide the executive or legislative actions undertaken by the government. If your lordship can refer to fact 44 of the compendium submitted compendium. The council seeks permission to submit a compendium with the bench.
Council, while we go through that, I have a question for you.
Much of my explanation.
You said that in your case, judicial review was applicable under 363, whereas 363 language very clearly says that the court should not judicially review any dispute which arises out of any treaty or something. But when there is a specific bar under a constitutional provision, where does this overarching power of judicial review lie in, say, a constitutional court of any dispute? This is a dispute, this is not a legislation. There is a distinction between a dispute and a legislation. So, how does, say, a Supreme Court assume power to decide or to weigh the pros and cons of a particular treaty?
Pertinent observation regulation. However, it has to be construed that
we want to know the specific source from where we derive this power for the constitutional court to review any piece of legislation or dispute that may be before it.
your relation, Article 13, along with Article 32, provides this court the power to review any of the legislative actions or executive actions undertaken by the government. If
32 is a procedure. 32 is a procedure.
indeed your lordship.
Is there any judgment of the courts which has interpreted these provisions to close the courts with this power? Can you cite any judgment to that effect?
Your lordship, in the case of L. Chandra Kumar versus Union of India, Article 32 and Article 226 were held to be the power of were held to be an essential feature of the judicial review, which is a part of basic structure of the constitution, and because Administrative Tribunals Act limited the power of Article 226 of the High Court, it was held unconstitutional. So Article 32, Article 226 and Article 13 of the Constitution mainly provide this court the power to review any of the actions undertaken by the government.
She is asking, how can this judicial review can be exercised? What are the powers to exercise the judicial review? Because 226 and 32 is the filing, anybody can file it. Whether that can be exercised by the Supreme Court, in what circumstances, what will be the circumstances to exercise that, whether the Constitution के against भी anybody can go, Parliament के legislature के खिलाफ कोई जा सकता है. These are the things to be decided, and these you have to rely on that.
Your Lordship, with respect to Article 32, the court can review any of the legislation which violates the fundamental rights of the citizens. And under Article 13, the limitation, there is an inherent limitation on the legislative power of the government, which mentions that it cannot violate any of the provisions of the Constitution. Apart from that, through exercising its
Just stop it. Now, Article 3, let's analyze this. Now, Article 363 very clearly bars the jurisdiction.
indeed, Your Lordship.
Will you open Article 363? It very specifically says that no court will enter into a dispute. How do you reconcile it with Article 13?
Your Lordship, Your Ladyship, in the present case, it is humbly submitted by the petitioners that there is no dispute which arises out of Treaty of Vienna. The petitioners have challenged the actions undertaken by the Union government, such as the emergency, the ordinance, and the reorganization order, in line with the provisions of the Constitution, along with the principles that enshrine that uphold those provisions. And that this bar is limited sense. It can the judiciary cannot be stopped from reviewing such actions which arises out of for reviewing the executive and legislative actions of the government. In the present case, primarily the challenge has been made to the ordinance, reorganization order, and the emergency which has been imposed in Guwahati.
Then 356 and 370, how do you distinguish that, whether that power under section 370 subclass A has been exercised in view of 356?
Your Lordship,
On the emergency of these states?
Your Lordship, when the emergency under Article 352 was passed in the present case, the Parliament enacted the State of Guwahati Reorganization Order 423. That particular order was made to repeal Article 371AA. It was not made. It was not under the any specific provisions of the Constitution. The Parliament enacted an order. However, it can only enact a bill under Article 3 to reorganize any particular state. And the issue of with respect to emergency and repeal of Article 371AA would be elaborately dealt by my co-counsel. If your Lordship are satisfied with the first fold of argument, the council seeks permission to proceed with the second fold of argument.
All right, try to conclude your first issue.
In the first issue, the council humbly submits that 107th Constitutional Amendment Act, which was passed during the proceedings of an ongoing case, prevented the Supreme Court from performing an essential judicial function, that is, of deciding the applicability of Article 363 in the present case. Apart from that, 107th Constitutional Amendment Act was not enacted, keeping in mind the Article 368 proviso subclause B, which says that if any entrance provisions of the Constitution are amended, then ratification of half the state legislature is required. In the present case, Article 131, the proviso has been repealed. Article 131 has been amended, which comes under Chapter 4 of Part 5 of the Constitution. If your Lordship can refer Article 368, it clearly mentions under the clause B of proviso attached to subclause 2 that if Chapter 4 of Part 5 of the Constitution has to be amended, the ratification has to be taken by the state, half of the state legislature. In several cases, the Supreme Court has held several Constitutional Amendments Act as unconstitutional because they did not follow the requirement which has been provided in this clause. One of such cases was Kyoto-Holohan, in which the 10th Constitutional Amendment Act was partly declared unconstitutional. Because of this reason,
Procedure for amendment is well defined in 368.
indeed, Your Lordship.
Okay, so which will prevail, the point you are talking about or 368?
Your Lordship, the Council has submitted the argument based on the provisions of Article 368 itself, and in any amendment of the Constitution, the Article 368 has to be followed. If any amendment is made under Article 368, the procedure laid by Article 368 has to be followed.
Now, as on date, it provides procedure and power to impose.
Indeed, Your Lordship.
Earlier it was only procedure.
Indeed,
Okay. Now it provides procedure and power. In this concept.
Indeed, not, Your Lordship. Even before the 24th Constitutional Amendment Act, the Article 368 provided both the powers and procedure to the Parliament to amend the Constitution. However, the phrase that Parliament has the power to amend the Constitution was not specifically given. It was clearly mentioned in the case of Bharti versus State of Kerala, in which the judgment of Bolan was overruled, that Parliament had already contained the power and procedure to amend the Constitution. However, Your Lordship, in the present case, the Parliament has to follow several procedural requirements under 360 under the Constitution to amend the Constitution.
In this case, are you proposing that the procedure was not followed?
Your Ladyship, it was Kyoto-Holohan.
In the case before us, was the procedure followed? Is there
Indeed not. The Council submits that the procedure laid down proviso which mentions that the ratification of half the state legislature is required when amendments have been made to subclause A to subclause E. It was not followed in the present case. The Parliament on its own passed the 107th Constitutional
So on
Amendment.
that ground, we are seeking a quashing of this application.
Indeed, Your Ladyship.
Well,
Correct.
The council, if the lordships are satisfied with the first issue, the council seeks permission to proceed on the arguments of second issue.
Please carry on.
Just one question before proceed. Can you just clarify it with regard to procedure? Only the procedure has not been followed, or there is another substantive part also?
Your Lordship, primarily the challenge remains with respect to the procedural requirement. However, if the consequences of amendments of the repeal of Article 363 are looked into, there can be challenges made with respect to the substantive limitations also. Because by repeal of Article 363, now the treaties, covenants or agreements have been made justiciable before this court of law. They cannot be claimed by everyone and every citizen of Indiana equally. They can be only claimed by those who had signed or who were made the beneficiary of such treaties or agreements. Therefore, it also violates the principle of equality enshrined under the Constitution.
Please respond, sister, that asked you one particular question. Okay, whether it's a contractual or it's a legislation, which is the, we have to respond on that also. Okay, in quashing that, whether it will be a legislature or whether it has to be, since it's a contractual resolution.
Your Lordship, if you can please repeat the question.
My sister judge asked you a question, a query, which is still to be responded. Okay, whether it's a legislation or it's a contractual which is to be quashed.
Your Lordship, the legislation in the form of 107th Constitutional Amendment Act has to be quashed. However, the contract in the form of Treaty of Magna has to be interpreted by this court to dissolve the present case, even after the bar of Article 363.
so to sum up, your argument is this, if we understand it properly, is that the court cannot look into whether the treaty was validly signed or what were the terms of the treaty, and they can't look into the validity of the treaty. But by looking into the validity of the law which has been passed
Indeed,
by
Your
the
Lordship.
Parliament,
Indeed, Your Lordship.
it will be open to them to look into the interpretation
Principle
of the
enshrined in that particular
in a
treaty.
particular treaty. Is that what you are saying?
Indeed, Your Lordship.
Well,
The council seeks permission, if the lordships are satisfied, the council seeks permission to proceed with the second issue. In the second issue, the councils on behalf of petitioners submit that the basic structure doctrine can be made applicable to those constitutional amendments that are made outside Article 368 and to those ordinary legislations that have the effect of amending the constitution. The submission could be made on a threefold argument. Firstly, the basic structure doctrine was propounded to limit the amending power of the Parliament. Secondly, ordinary legislative procedure can also be used to amend the Constitution. And lastly, in the present case, ordinance and the reorganization order which have been passed by the Parliament substantially amend the Constitution and violate the basic features of the Constitution.
Crux, you just tell the crux of the matter, Article 369, that is the temporary power of the Parliament to make the laws and all that. Whether that temporary power can be withdrawn, and if that can be withdrawn, then the Parliament has every power where the judicial review comes. And for that purpose, all those states where this power was exercised, they were deprived of the human rights protection and all that. They were deprived from all those benefits, and therefore this temporary provision has to go.
Your Lordship, in the present case, the state of Guwahati was firstly joined in the Indiana territory as the union territory. However, after the insertion of Article 371AA, it was termed as a state. The term state includes all the states, and it is provided in the first schedule of the Constitution. Article 369 talks about those matters in the state list that Parliament can enact a law upon, and in the present case it would not be applicable because Huadia has been provided its own constitutional mechanism to act upon, and it has been given a special status under a separate provision of the Constitution. It does not come under the temporary or transitional special provisions.
Carry on.
Your Lordship, it is humbly submitted that the amending power of Parliament can be exercised through ordinary legislative procedures. In the present case, Article 371AA, Clause 5, provided the Parliament to amend the said article to supplement and to give effect the provisions of the said article, and this would not be considered as an amendment under Article 368. Your Ladyship, it is humbly submitted that such other provisions are also provided under the Constitution in the form of Article 4, Article 169, Schedule paragraph 21.
You need to say ordinance is not part of the law.
Indeed, not, Your Lordship. The Council.
So just open Article 13. See the definition, but how the law is defined, what it proves. 13(3)(a). Law includes.
Your Lordship, law includes ordinance, order, bylaw, rule, regulation, notification.
Ordinance is very much part of that.
Indeed, Your Lordship, ordinance is a law and it can be challenged under Article 13 as well. The contention of the Council here is that along with Article 13, it can also be challenged under the basic feature of the Constitution because it has amended certain provisions of the Constitution. Parliament, by providing unfettered discretionary powers to the Lieutenant Governor through the ordinance, has amended Article 200 with respect to Huadia. Article 200, if Your Lordship can refer to Article 200, it mentions, it provides the procedure through which any legislation would be passed by the Parliament or legislature. If it mentions that the executive authority of a state has to comply with the decisions taken by the legislative authority. However, in the present case,
200 give it mandatorily or it provides for the governor for 3 procedures. Just go through. Whether it is mandatory to whatever.
Your Lordship, the Governor can reserve his assent with respect to the bill. However, if the Parliament again passes the bill, it is provided that the Governor shall not withhold assent therefore. In the present case, it is mentioned that the aid and advice of the Council of Ministers would not be applicable to the Lieutenant Governor in the Huadia. Therefore, the Parliament, the Legislative Assembly of Huadia, has no power to make him follow their consent and follow their advice. This affects the legislative powers of the Legislative Assembly of Huadia and amends Article 200. Apart from that, in the case of GACTD versus Union of India, it was held that the executive powers of a particular government are extends to those provisions where it has legislative powers. In the present case, the Huadia had the legislative powers with respect to all the matters enumerated in the second list of 7 schedules.
This court has given very wide interpretation of legislative power in Ram, Doria, Varsad, Tribunal. Have you come across that?
Your Lordship, indeed, Your Lordship, the court has, according to the rules of interpretation, every entry has to be interpreted widely by the court. However, in the present case, Huadia had all the powers to legislate upon with respect to the entry to list second or 7th schedule because it is a state under the Constitution. All the entries except the public order, police and land. With respect to this, the Council contends that the repeal of requirement by following the aid and advice of the Council of Ministers is not applicable to just 3 entries. It is also applicable to all the entries. Therefore,
List to, you mean to the concurrent?
if Your Lordship can repeat the question.
List to, you mean concurrent list?
Indeed, not Your Lordship. It is the state list which has been talked about. Therefore, the Legislative Assembly of Wardha is now less capable of enacting laws with respect to those the list enshrined.
Okay, then this court would like to know you, in case of any repugnancy, inconsistency between the matter of state list and union list, which will prevail?
Your
You will
Lordship.
refer to 48 sometime. Entry number 97 of this state is also very clear about that.
Your Lordship, NT 97 provides the responsibility power to the Parliament, but it is with those subjects which are not even mentioned in any of the list, in any of the three lists of the 7th schedule. In the present case, the powers of the Legislative Assembly of Wardha has been prescribed under list 2 of 7th schedule. Only those three entries, only several entries of the list 2 have been given to the Parliament. However, the remaining entries have been provided to the Legislative Assembly of Wardha itself. Therefore, apart from that, Article 162 of the Constitution provides the executive powers to the government, the state government, with respect to those entries which it has the power to legislate upon. In the present case, in the GNCTT versus Union of India, it was held that the Lieutenant Governor need to abide by the aid and advice of the Council of Ministers in those matters which fall under its legislative competence. However, in the present case, the concept of aid and advice has been completely ruled out by the passing of ordinance by the Union government. Therefore, the aid and advice of Council of Ministers with respect to those entries which it has given the power to legislate upon cannot be taken into account by the Lieutenant Governor. And apart from that, therefore it violates the rule of representative democracy because providing such huge discretionary powers to the Lieutenant Governor, who is the nominal head of the state, ignoring the elected legislature of the state, has violated the principle of representative
Just a
democracy.
minute. With reference to your case, what discretion should have been with the Lieutenant Governor? And which is violated?
Your
On
Lordship.
that, and definitely we would like to have some source or authority to in submission of your claim.
How it has been abrogated? You have mentioned in your prayer that the abrogation of the special status of the state of India is unconstitutional. How it affects you?
Your Lordship, the citizens of Wardha enjoyed the statehood under Article 371AA. However, Parliament has repealed the same article by the State Reorganization Order of Wardha. Therefore, it violates their right to remain in a representative democracy, right to statehood, and the principle of asymmetric federalism, which is provided under the Constitution and governs the relations with the central government of different states.
You have coined very good term, representative democracy. Okay, this court would like to know from you, which portion, which article of the Constitution talk about this term?
Your Lordship,
No, it is very common, sometimes it is not to turn off the pages.
it is the article which provides for the formation of parliament, which includes Lok Sabha, Rajya Sabha, and the president itself. It is an example that India is a representative and parliamentary democracy.
Why council want to go so deep? Haven't you gone through the preamble of our constitution?
Your Lordship, it is also provided in the preamble, but the provision specifically mentions that
That
particular.
is the tool to open the mind of the framework of constitution.
Indeed, Your Lordship, preamble provides a gist of the Constitution along with the intention of the makers of the Constitution.
So as my learned friend is asking you, is it not that the preamble provides the basic spirit of our entire constitution and the whole theory of basic structure? Because basic structure is a nebulous concept. It's a doctrine which is not penned down in articles. So where would you look at the values? So what is it in our constitution that shows us that these are the values which we uphold, which are non-negotiable and cannot be amended? Where will we find that?
Your Ladyship, in the Minerva Mill case itself, the court has held that the basic structure of the constitution is not a twinkling star in the sky. It has to be found in the terrestrial concept of the constitution itself. It has to be construed out of the provisions of the constitution itself. Therefore, some of the provisions which have been amended or violated by the parliament in the present case, including Article 200, apart from that Article 162 with respect to Wardia, and the principle of rule of law which is enshrined in the Article 14 of the Constitution. These provisions show that there are several features of the basic structure which can be found in the provisions of the Constitution itself. Apart from that, your lordship, it is humbly submitted.
If they were not found in the constitution, would we be bound by something as nebulous as a basic structure?
Your ladyship, it is humbly submitted that the basic structure of the constitution can be construed based on the provisions. Apart from that, the amalgamation of several provisions of the constitution and including the preamble of the constitution itself. It can be interpreted by the court according to the facts and circumstances of each case, the constitutional identity, the basic principle of constitutional identity. If any of the provision is amended or repealed from the constitution, does it affect the constitutional identity?
So what is the test? What we are grappling with is what is the length and breadth and what is the test of a basic feature? Is it a value? Is it a particular procedure? Is it a particular right? What is it? What is your, we want to know what is your understanding of the doctrine of basic feature?
If the parliament or the constitution takes care of the dignity of a person, how it violates, it is not a violation of basic structure, nothing of the kind.
Your lordship,
in 2 sentences, give us, taking note of what the presiding judge has said, what is the meaning of the doctrine basic structure?
your ladyship, in the case of Keshav and Bharat versus State of Kerala,
Don't quote anything, just give us your understanding.
it is the substantive limitation which has been imposed on the parliament so that it cannot amend the constitution on its whims and fancies. If your lordship can allow this extension, it is imposed on the parliament so that it cannot amend the constitution based on its own whims and fancies, ignoring the values which were always be there in the constitution, the values which has
The
been
concept, ladies, is very clearly asked. You are answering 2 sentences, and it can be given, right? Your time is over, so if you can conclude in 5 seconds.
Just formulate it and give us the understanding in 2 sentences. Don't quote anything.
Your understanding.
You are doing very well, but just formulate a proposition.
Basic structure of the constitution is a doctrine which provides how the constitutional identity has to be maintained by the parliament with respect to the amending powers it has been provided with, keeping in balance the amending powers it has with itself and the constitutional identity which has been provided by the constitution makers of the India.
And where does the judicial review come into this?
Your ladyship, the judicial review can come under Article 32, Article 13 itself, and
No, here there is a specific authority. I understand which ladies want to know. There is a specific authority, judicial review, basic structure of constitution. There are so many cases.
The oldest case, Vishwanand Bharati,
indeed, your lordship, and there are a series of cases in which various constitutional amendment acts were challenged based on the basic structure doctrine, such as Minerva Mills, such as Vaman Rao, and all other cases that could have been quoted by the council, but because of the paucity of time, the council concludes that in the present case, various provisions of the constitution have been amended by the parliament using its ordinary legislative power, but such power cannot be considered as ordinary because it amends hence the Constitution.
All right.
It must be subjected to basic structure to uphold the constitutional integrity and identity. If your lordships are
All
satisfied.
right. We have given you too much time. I have your
Uh,
go
You
confidential.
have done your best, but bad brief.
It was an honor to be with you.
Thank you.
Now the council yields the floor to the co-council.
Thank you.
Thank you.
Yes, next.
Please.
You supplement all those questions which have been left.
Greetings to the Honorable Bench. The Council seeks the permission to address the bench collectively as your lordships. The Council will be here contending the third and fourth issue, that is whether the abrogation of third issue is whether the proclamation of emergency is constitutionally tenable, and the fourth issue, that is whether the abrogation of special status of the state is constitutionally sustainable or not. Now the Council will like to proceed with the third issue.
So, council, because your co-council has taken so much time, we won't give you much time to tell us about whatever you want to tell us, and we just shoot questions to you. Is that okay for you? We'll give you 1 minute to put your propositions, and then we will just shoot questions to you.
Your Lordship, in the interest of justice, I appeal to the court that please just allow at least a few minutes.
1 minute. Carry on. Quickly. Shoot.
Your Lordship, under plain of Article 352, the three essentials come out, that is the satisfaction is required for the that a grave emergency exists, a grave threat to security of state existed, and the satisfaction has to be on the review cabinet advice, right? So, on various cases it has been laid down that judicial review is the part of basic structural doctrine, and the satisfaction can be subjected to the judicial review in the context of.
No, but your issue. Judicial reviews you have lot of.
Your Lordship, there the Council would like to contend the fact that the court can actually see if the satisfaction of the person existed on the grounds of malignant intention.
My question is very clear. What is the issue you are arguing?
That is the proclamation of emergency was
Come
constitutional.
on that.
Yes, Your Lordship. So under Article 352, a proclamation of emergency has to be
Your matter is before 44th Amendment or after 44th Amendment?
after 44th Amendment, Your Lordship.
All right. What is the major thing? And ladies, you have already commented. We will be shooting question now. What are the major changes taken place after 44 in relation to your, your case?
Your Lordship, after 44th Amendment Act, Article 352 was amended to include armed rebellion in case of intolerant disturbance as a ground for proclamation of emergency. This meant that now for the proclamation of emergency, the ground has to be of less effect. The situations which actually violate public order and does not violate security of state is not to be taken into account. Public order simply means public security.
What is the test of armed rebellion?
Yes, Your Lordship. So basically, armed rebellion has to be taken into two situations: insurgency or civil wars, or where there is an armed revolution, basically. Right? There has to
Okay,
be
you mean to say an exhaustive definition can be given for armed rebellion? A definition which can be put in the steel jacket or watertight compartment or what?
In which case did the Supreme Court study the aspect of armed rebellion and defy the contours?
So in various cases it has been held, such as Nagas, people movement on the human rights, as well as extrajudicial victim families cases. In most of the cases, court held that as compared to intolerant disturbance, armed rebellion has a lesser ground. And also about the water straitjacket formula of defining an intolerant ground, the one point that has to be noted is that it should be a grave threat to the security of state. And
So armed rebellion is an internal threat or an external threat territorially?
internal threat, Your Lordship, it has been in place in the ground as an internal threat to the security of state.
But
And
there are
that will
two.
be confined only to a particular area of the country, or it's an external threat to the entire country?
Your Lordship, your petition depends on the extent of what the armed rebellion is or how it is posing the threat to the
tell us very, very simply, is it limited only to a part of the Indian territory or the country's territory, or is it extending to the entire territory, in as much as the proclamation of emergency will apply to the entire territory or just a part of the territory?
In present case, Your Lordship, it is simply restricted to a territory. It might be also there to the whole territory itself. In that case, proclamation of emergency can be done for whole territory as well, but in present case, it is restricted to state of Guwahati. Also, there are mere protests. There is not armed rebellion as such, because armed rebellion actually entails some form of armed revolution or some form of violence, some form of loss of lives. There is none in this case. Merely
There are two words, infinitive. One is armed rebellion and one more word. If you call this suffix, that will be prefix. What is that?
Sorry, Your Lordship, I did not get
There are two words. It's not only an armed rebellion. What is before that?
Before that, it's insurgency, Your Lordship. So, when the protests are turning violence and
Some
instruction basically.
No,
What was the circumstances?
Very good.
Brother is asking what was the circumstances in that is in order to exercise their power.
Your Lordship, the circumstances in which that followed this proclamation of emergency was before the proclamation of emergency was that widespread protests were happening all around the state, and these protests were done because the people were normally in a dissent with the government. They did not. They wanted to consume their ethnicity. They wanted to preserve their ethnicity, and because for such preservation of such pluralism and heterogeneity and conservation of their own identities.
Can emergency be declared vis-a-vis a part of an area or for the whole country?
It can, proclamation of emergency in Article 352 can also be declared for a part of territory, Your Lordship. That has been done in this case.
It is part of the, not for the whole country.
It can also be done for whole of the country as well. It can be a part
In
of
this case,
territory.
it's a part of country.
It is a part
So
of
it has to be examined with regard to that particular state of affairs.
Your Lordship, internal disturbance has to be taken with regard to that state, and the external emergency factor, that is the external aggression war, has to be taken outside the periphery of the state. So basically, here it is contended that the protest happening is not of violent nature, is not leading to any loss of lives or anything before the proclamation of emergency, and as such cannot be just said to pose a grave threat to the security of state.
But Council, there was a missile which was fired, which also led to a lot of violence and disturbance of the public law and order. So how can you contend that it was not to such an extent that there should not have been a proclamation of emergency?
Your Lordship, for the internal, first of all, the firing of a missile would have been contended as an external aggression factor, not internally, because it did not arise from any internal factor for Guwahati. Secondly, such missile fired from outside. The Defence Minister of last team clearly held it out to be a mistake and apologized from Indiana for the same. If we just allow the government to proclaim emergency in just this case where there is a simple apprehension of one external aggression factor of firing a missile, then whenever anything like happens, a dispute arises with other countries, and there is any misapprehension, miscommunication between countries, the government can proclaim emergency on the basis of that. As well as the internal disturbance ground that is used is not a ground anymore, Your Lordship, in the Constitution, Article 352. Even the part under 371A of the Constitution, clause 6, says that such emergency has to be proclaimed under Article 352. So, it would be subject to the same amendments as under Article 352, Your Lordship. Also, proclaiming emergency of internal disturbance base and then contending that external aggression factors existed keeps public in doubt.
All right, you were just referring, you started referring 358.
371A.
358 also.
358.
That is the fact.
Yes.
And that is given in the proposition also.
Yes, Your Lordship.
Right? So you must take consideration of that. So, but the question my candidate has asked, once the emergency is in a particular part of the country, can Article 19 be affected in other areas also?
Be suspended.
Can it be suspended?
If that is the later part of the country can be suspended if there exists a ground
No,
of
even in the portion where there is no emergency.
Your Lordship, if you just allow me to read the article once.
Read 358(2).
That was suspended in many states when the occasion arose.
This is something which is part of your proposition.
Yes.
So this would expel from the concept that it must be very clear about that.
Your Lordship, the fact here is that Article 19, though was not suspended in any other part other than Muadia itself, the suspension can be done, but it is to be noted here is that Article 358 only provides two grounds, that is war and external aggression for suspension of such rights. The proclamation of emergency has been done under internal disturbance argument, and such cannot be a ground for suspending Article 19 under Article 358. It clearly goes beyond the scope of the statute, and hence Parliament does not have competence to do so. Parliament does not have the competence to do so clearly. Also, it is to be noted that this basically shows the extraneous or irrelevant considerations of the grounds that the Parliament has taken and the President has taken while imposing the grave emergency. The magnified intention has to be also taken from the fact that the state of reorganization of order was passed just after the proclamation of emergency. The time factor has to be included by considering if the order was passed for the beneficiary or for was actuated by improper motives there. The fact that in SI format the court clearly laid down that it can see materials to see.
Wait, just see. Once the emergency is part of the state, so how does legislative work of Parliament affect?
How the
Legislative work, which you say they have taken decision, how it will affect?
Your Lordship, it is contended that Article 19 suspension itself was void because of the fact that Article 358 does not contain internal disturbance as a ground for suspension of Article 19. It goes beyond the scope of statute, Your Lordship. If they had the ground under war and external aggression, that might have been considered even for a moment, but not internal disturbance or armed rebellion, even not existing a ground under Article 358.
All right, Harry. Once your proposition say that twice they have caught the people entering to the country through that portion. So what are you taking it? Whether it is external aggression, the people they are throwing people inside it, they are firing missiles. So what are you taking?
The Lordship, the Council contends with the fact that under Article 355, the state has the Union has the duty to protect states, and it can deploy central alternative forces to deal with infiltration issues for sure. Border issues and infiltration issues are a part, but also after fencing, it has been reduced to a significant.
You mean to say it is the state or is the union government, they will take decision how to face with this problem?
Your Lordship, that's true.
They have option.
The policy decision making of what to operate is definitely an ambit for the executive and the legislature to take the decisions, but it is to be contended that it should not be excessive. It should be proportional. That has been held in SR and proportionality has to be seen in magnified or irrational palpability according to Justice Sarkar and according to Justice Reddy's advisability and necessity. So when seen in both four areas, there was no such grave necessity. It could have been for
What will constitute rationality? What will constitute grave necessity? What will constitute the deadline from where we will say that now it is excessive and now it is within the limit? If you can give some authority and speak on that.
In Ram versus Spain, the definition of armed rebellion as such has held to be the fact that there should be some armed revolution or insurrection. From that moment, it can be said that there is a grave threat to security of state. Even in infiltration,
Also, we're talking about leading case on proportionality, not on the definition of armed rebellion. Give us some proportionality. How do we determine whether the action is proportional to the?
Naga's movement and the Naga's people's movement on the human rights actually led to that differentiation of whether martial law and which situations entail the imposition of martial law and which situations entail the imposition of emergency or lordship. So in that case, it was clearly held that whenever there are situations which are not in that grave emergency extent, where so in that case there was a millions of people entering into the state, and that was held to the threat of security of state, and
how does this, what are the values that you're balancing? Because on one hand, we have the issue of federalism, where we have the provincial autonomy. So when a state has list 2 with it, in which law and order is entry number 2. So when all these are within the state's domain, how does the union, on basis of 352 or 356, get any authority, moral authority? Of course, they have the power under this. But how do they get into the affairs of the state? Because we are now defining only a particular territory. We are not looking at the entire, I can understand with regard to a national threat. But when it is only a provincial threat, what is the justifiability of union stepping in and making laws for the state, declaring emergency and so on and so forth? So what's the weighing that you have to do between federalism and union power?
Material and basis. She is asking material and basis what was it.
How do you weigh what outweighs the other? And most of all, the suspension of Article 19, which is the heart and soul of our constitution. How do you justify that?
Your Lordship, this is counsel for petitioners and they are clearly contending that Article 19 has been suspended under grave violation. First of all. So we are not...
Tell us why. Why are you pretending that there has been a grave violation?
Because they exercise their power beyond the scope of statute, Your Lordship. They suspended Article 19 under Article 358. Article 358 does not have a ground for internal disturbance for suspension of Article 19, Your Lordship. And going beyond the scope of statute is clearly a violation of Article 19. And similarly, Article 21 has done for the intersection of Article 19. Contended on other grounds that what are the principles to be weighed. Again, the argument that the deployment of alternative causes can be seen is to be seen from the cause of that public order as a domain lying with Parliament in this case, and then when there is a danger to public order, then it can step in. Before that, they can actually let the whole state control the situations of law and order. And also, emergency power has to be exercised when, again, there is a great threat to security of state. Security has been definitely placed above federalism principle. As Dr. B.R. Ambedkar has also held that in many of the structures, that our constitution turns unitary in nature whenever there is extraordinary emergency power. But also, Your Lordship, it has to be seen in the fact that such a unitary power was exploited by the respondents in this case. So that
that's a conversation, what my co-leadership want asked to you. We are expecting something else. 350A subclause 2 after proviso. See, there is a particular word given over there. We were expecting an argument on that. See the exception portion. Where to apply and where not to apply.
Proclamation of emergency is an essential definitely for suspension of Article 19, and security of India has...
Come on, clause 2. Nothing in clause 1 shall apply.
Which does not contain the recitals to be present as such law is...
ये कहाँ चला? Where it has gone from your argument?
And just one more thing before you respond. Whether the power of judicial review, can the court exercise that power, deciding whether the decision, if there is a public disorder, if the law and order problem, it's an executive action. Can judicial review be done on that ask?
So judicial review as held by SR
Can we decide whether the executive decision, when there is a law and order problem, there is a grave law and order problem?
correctness and adequacy of the facts cannot be taken into factor for sure. But judicial note of fact and circumstances can be taken as the material on the basis of which proclamation was emergency was proclaimed has to be seen. There has to be a reasonable nexus between the materials, that is the judicial facts and circumstances arising in the case, with the proclamation of such emergency. And hence, due to the law laid down in SR domain itself, the court gets the power of judicial review, and if they find that such an exercise in malified, perverse, extraneous consideration, irrelevant considerations are taken into
having missiles being fired, you don't consider it an emergency situation?
Your Lordship, again, this was one of the factors for sure, but such a firing of missile was done due to a human error from the device of cyber blasting, and this cannot be just taken one of the factors for just contending that there existed grounds to the attack.
That the minister made a statement doesn't take away the assessment by the national authorities. So the national authorities would have made an internal assessment, security assessment, whether the apology that is tendered is genuine or not. How can the court go into what these factors are, what their intelligence is?
Again, Your Lordship, the court cannot decide the correctness or adequacy of facts true. And the court cannot go into reasoning of why the court cannot go into the factors of what were the executive policy decision making that these facts were true again or not. But the materials, that is the judicial notes and facts and circumstances, the human error is a fact that they proclaim. Now the government side to just argue that assessment of ours posing a grave threat, there is an apprehension basically. So in view of such apprehension, they proclaim emergency. That's let's
But what would you just imagine a hypothetical situation? What would happen that the statement which was made by the minister was only lip service to international relations, and our government had material and apprehensions to apprehend that this is just a precursor to further aggression into the external affair, into our country. So how can the court go into all these factors?
Because this consists of material on the basis of which proclamation of emergency was
How
contained.
can the court even look at this material? This is the question.
Yes, as I held that court can look into the materials for which proclamation is contained. Though
But
government
if
can
the
argue.
government says that we have material that this is still a threat for the country, can the court go into that material? What the intelligence report is, what the military report is?
If it is injurious to the security of state by going into the materials, the court can definitely look into it privately and help if the materials are actually posing a threat to security of state or not. But yes, they can go into the material assessment.
But then you're contending that there are no limitations to the power of judicial review.
No, there
You're
are
making your
limitations.
field completely open to the courts.
The limitation of justiciability and judicial reviews are very different things. We are not deciding that the emergency powers was just or not. We decided that the power was nullified, was based on extremist consideration. 44th Amendment Act took away the concept of donor disturbance, still they proclaimed emergency on the basis of extremist grounds. Similarly, external aggression factors and internal aggression, even if we don't take the factors for a moment, they proclaimed emergency on the wrong grounds, keeping public in doubt, violating their articles, right to articles, right? Suspension of Article 19 was clearly wrong, and similarly nullified because the state of reorganization order of body was passed very soon and suspended state legislation.
All right. Now you have only 1 minute and one issue. It will remain unargued.
Your Lordship, in the council seeks
1 minute. You have 1 minute to do it.
the council seeks extension of 2 minutes just to finish reading, Your Lordship. At least,
Okay.
1 minute.
You justify something. Yes.
Formulate the proposition.
You justify something. One thing I may tell you, that in 1974, the emergency was exercised by the government for the whole country. Have you heard it? Under Article 352, the power was exercised for the whole of the country. And what was the material there? That was something material which has exercised, which has led to the government to exercise that power, and therefore that power cannot be exercised by the judicial review.
Your Lordship, that case was of 1974. Today we are living in 2024. Government has held that material can be seen to
Why
establish.
hasn't amended the constitution?
If not, as 44th Amendment clearly said that it placed limits on the constraints, and by subsequently court being the interpreter of the constitution held judicial review to be a part of basic structure, held that such satisfaction can That is the point here. So
Anyway, your next
It's
issue
a motion.
quickly.
Yes, Lodgers. So here it is contended that abrogation of Article 371A, the Parliament does not have competence to do so without an amendment to Article 368, because it basically means amending the Constitution, Your Lordships, and they have done so under Clause 5 of 371A. Clause 5 gives the power to Parliament to give effect or supplement the provisions. It does not give the Parliament the power to repeal or alter the constitutional identity of the Constitutional Amendment Act, Your Lordship. So there lies no competence and power to do so. Also, a Parliament cannot convert a state completely into a unity under Article 3. Even this question is definitely stand.
What Article 3 say about that?
Article 3 says
It's a complete drill. It's a complete drill given over there.
Yes, Your Lordship.
Okay. Come, please stop that.
Article 3 basically says that Parliament can alter the boundaries and alter the boundaries or limitation boundaries of the state. It can basically form a new state by combining two other states, a state and a union territory. It can carve a union territory out of a state, and it can basically make two union territories out of a state. But it does not give that more disruptive power facing the principle of constitutional or federalism under Article 3 without even the recommendation of the state legislature, Your Lordship. There has been no recommendation taken from state legislature to reorganize the state. There has been no recommendation taken under Article 371A.
All right.
Precisely.
Yes, perhaps this will be the almost last question, if you also permit me. See, your proposition started with the first part, and there are two principal points in that. One is the judicial review, we have discussed a lot. Another one is the principle of implied power. So when you use this principle, first of all tell me who coined this principle, it is in your proposition itself.
Principle of implied power was actually given by US Supreme Court judge.
In which case?
Macaulay versus Maryland, Your Lordship.
Maryland. So, in context of your matter, okay, and particularly when you are describing Article 3, so why do you forget the implied power of the?
Your Lordship, that is because of the fact that implied powers contain that the meaning has to be taken from the intent of legislature as well. Here, when we say that the intent of legislature has also been taken into account, there has also been to see that harmonious principles have to be applied. The alteration of basic structures of principle of federalism cannot be just opposed to when implying doctrine of implied powers. There are some basic identity of the Constitution, and that cannot be even avoided by doctrine of implied powers, Your Lordship. Hence, in the present case, even Article 3 should be harmoniously constructed with the principles of consent, autonomy, representative democracy, accountability, and 371A being the sui generis model that it is, defining the relationship between Union and India. It is, by abrogation of it, it is avoiding all of these and violating the basic structure doctrine, Your Lordship. That is the main of the contention.
All right. The country from where you have taken this power, they have police power. Okay, but we do not have such type of power here.
Police power.
Yeah.
Your Lordship.
So implied power, it plays a very important role in case of emergency, particularly.
You keep in mind that always argue slowly. You are such in a speed that when you will argue in the court will say, all right, we have heard, you give your written arguments. The court will reply that you give your written arguments.
Apologies, Your Lordship.
Therefore, be slow, be slow.
I fully endorse my letting this to you. I was going to say, please stop and given your time is out, please give your written submission.
Apologies, Your Lordship. I take that into consideration.
Apologies, just a point.
All right,
Your
come on,
Lordship.
say.
Your Lordship, if I can just take an extension to wrap up the argument for your Lordship's assessment.
No, it's over. You are right.
Thank you so much.
Thank you.
Therefore, in the lines of facts stated, arguments advanced, precedent principles and provisions cited, in the interest of justice, it is most humbly prayed that Honorable Court must declare, quote, adjudged that the jurisdiction of the Supreme Court cannot be ordered during the ongoing case by 107 that the basic structure doctrine applies to those Constitutional Amendment Act that are not made under 368 but has an effect of amending the Constitution, that the emergency provision under Article 352 is constitutionally untenable, that the abrogation of special status of Huadia is not constitutionally sustainable, and or pass any other order that it may be pleased to in the interest of justice, equity, good conscience, and for this act of kindness, the counsels on behalf of petitioners shall duly bound forever brave. Respectfully submitted counsels on behalf of petitioners. It was an honor to argue before the bench. Thank you.
Thank you.
Thank you. Yes,
The council seeks permission to approach the dais.
yes.
Much obliged, Your Lordship.
Before you start, we'll giving you a statutory warning. Again, we will not give you too much time to develop your arguments, but we'll just fire questions to you, which should include your arguments when you reply.
Indeed, Your Ladyship. Am I audible? Your Ladyship?
I don't think so.
Now. Greetings to the bench. This is the council on behalf of Union of Indiana in the case of State Government of Huadia versus Union of Indiana, read with Mr. Matthew versus Union of Indiana, read with Mr. Jason versus Union of Indiana. The council,
Please.
Your Lordship,
Please, you are.
Your Lordship, the council just mentioned the name of the parties. So on the cover page of the council written submission, you will find the name of the parties. The council is approaching this honorable court under Article 32 of the Constitution. The council seeks the permission of this bench to collectively refer to the bench as Your Lordship. Much obliged, Your Lordship. If Your Lordships are well versed with the facts of the case, the council would like to proceed with the arguments at once.
Please proceed.
Indeed, Your Lordship. The present dispute will be dealt in the form of 4 issues, namely 1. Whether the jurisdiction of the Supreme Court can be altered during an ongoing case, thus necessitating the examination of the constitutional wires of the 107th Constitutional Amendment Act of 2023. 2. Whether the basic structure doctrine is applicable to those constitutional amendments that are not made under Article 368 or to those ordinary laws that have an effect of an amendment. 3. Whether the proclamation of emergency under Article 352 of the Constitution of Indiana and Huadia is constitutionally tenable. And 4. Whether the abrogation of the special status of the state of Huadia thereby causes a fundamental constitutional alteration, and is it constitutionally sustainable or is it fraught with constitutional mischief? The present council will be dealing with issues 2 and 3 shortly, followed by the co-council who will be dealing with issues 1 and 3.
So you are starting with 3 and 4?
No, Your Lordship. The council will be dealing with issue 2 and 3.
2 and 3.
Indeed, Your Lordship.
Leaving 1 and 4.
My co-council will be dealing with issue 1 and 4. Your Lordship.
Okay.
So council, tell us very shortly that how do you say that your action, how does the state's action not violate the basic structure of the Constitution?
Your Lordship, the council would like to clarify, your leadership is asking this in what context?
In issue number 2, because you are defending the legislation,
Indeed, Your
you
Lordship.
are defending the amendments. So you tell us how they don't defend the basic structure doctrine.
Indeed, Your Ladyship.
In 2 sentences.
Indeed, Your Ladyship. The basic structure doctrine is only applicable to those amendments that are made under Article 368. This amendment has not been made under Article 368 and instead is a part of an ordinary legislation which is specifically comes under the purview of Article 13, which scrutinizes it as a part of judicial review. Therefore, this council is submitting, and the council is no one questioning the authority of the court to look into the validity of the ordinance made by the parliament. But the council is simply submitting that it would not be by the virtue of the basic structure doctrine as this amendment has been made by the way of an ordinary legislation.
But the council for the petitioners just contended that this was a mischief which was played by the executive in as much as the timing and the device which was used is mischievous. Something which should have come by way of an amendment has been brought in by the back door through a legislative process by way of a statute. So how can the court not go into the vagaries of the statute on the basis of basic structure doctrine? Does it not have to meet the test of the basic structure doctrine? The statute does
Your
not.
Ladyship, the council would like to clarify that the court can do so under Article 13 based on two grounds only, which essentially reflect what the judiciary intend to do by bringing in the basic structure doctrine case of Nanda. If the court may allow me to say, under Article 13, the validity of any ordinary legislation can be questioned on two grounds, that is lack of legislative competence and two, violation of any fundamental right or any other provision of the Constitution. Therefore, this council submits that if the court has to view the validity of the act or ordinance made by the government, it shall do so under these two grounds, which essentially encompass the very intent, the judicial intent with which this.
So any other provision of the Constitution being violated, which is the case of the Supreme Court, where they expand the jurisdiction which would lead to violation of 14, 19, 21, which is the case in which they expanded the jurisdiction of this test.
Your Lordship,
Can you think of?
if you're referring to the Golden Triangle, that is applied in the case of Maneka Gandhi versus Union of India, if that is the reference that is being made.
No, so in McDonald it was held that there are only two grounds. One is violation of the, one is the competence, and the second is the violation of fundamental rights under 21. But then the Golden Triangle was expanded later, and I think it's a Justice Nariman's judgment, where the judicial test was expanded with regard to the violators of the statute. Which case is that? Would you be able to think of that?
All right, the research is working on that.
Your Ladyship, like you pointed out, by even these grounds can be expanded at the discretion of the court. Therefore, the council is urging and substantiating the point put forth by you that you can do so under Article 13 and need not bring the ordinance made by the Parliament under the scrutiny of the basic structure doctrine, as has been statutorily provided by the Constitution. Furthermore,
So your proposition is that basic structure doctrine is not even required to test the legislation.
Indeed, Your Lordship. That is because categorically the whole reason why judiciary brought in the basic structure doctrine was because to fetter the powers of the government, wherein it made amendments under Article 368. So there is a strict application of Article 368 with respect to the amendments that are brought in under Article 368. Whereas the current ordinance is passed by the way of a normal or ordinary legislation which only requires simple majority. And its scrutiny, the court does have the power to look into the validity of this ordinance. However, it shall be done only under Article 13 on two established grounds.
So the distinction you are trying to make out is that for an ordinary statute, the principle of 13 would apply.
Indeed, Your Lordship.
Or 368 basic structure will apply.
Indeed, Your
So
Lordship.
since it is not a 368 legislation, so therefore it is basic structure will not apply.
Indeed, Your Lordship.
It will not amount to basic structure amendment.
Indeed, Your Lordship.
It is an amendment in the emergency. You have pointed out issue number 3, whether the proclamation of emergency under Article 352 of the Constitution of India in such and such is constitutionally tenable. How you would say? You just argue it on this point.
Your Lordship, this ordinance is not with reference to the proclamation of emergency. This ordinance in question is with respect to the fact that the President issued an ordinance which enlarged the scope of the discretionary powers which were available to the Lieutenant Governor. In this case, originally the Lieutenant Governor could basically, in case there was a conflict between the opinion of the Lieutenant Governor and the Council of Ministers, he could write so to the President, who would then basically tell what the way was, and the opinion of the President would prevail over there. However, after this ordinance was brought in, the scope of the power of the Lieutenant Governor was expanded, wherein now he can exercise his discretion and doesn't need to seek the aid and advice of the Council of Ministers. What he only needs to do is, in case he disagrees with the Council of Ministers, he needs to explain his rationale to the President in writing, which is a formal process.
So here's a question for you. The Council for Petitioners refer to representative democracy and the value of representative democracy. how do you respond to that with reference to SRMI's case? How can the Council of Ministers' opinion be justifiable? How can a proclamation which totally takes away a representative democracy principle be upheld by the courts?
Your Ladyship, the Council would like to establish this answer in a twofold manner. While in under normal circumstances, this would prevail, where the Council, suggestions or the advice of the Council of Ministers would prevail. Huadia is a sui generis model as agreed to by my learned opposing counsel, which means in this specific case, what has happened is that the appointment of the Lieutenant Governor is ratified by the people. Essentially, the council is submitting that the appointment of the Lieutenant Governor is an explanation for the will of the people. So therefore, we can't say that the will of the people was not taken. Why? Because the Lieutenant Governor, while the executive may propose a person to be appointed in the position of a Lieutenant Governor, the people of Huadia retain the absolute right to ratify his existence in that position or not. If they deem the person to be unworthy to be the Lieutenant Governor of their state, they may simply not ratify his appointment. But the fact is, if the council may refer to the Moot proposition para number 32, the last line clearly says, further it was also stated that the Lieutenant Governor shall be appointed only after the name of the person to be appointed has been ratified by the State Legislative Assembly of Huadia.
Which provision is that?
Moot proposition?
No, provision of the Constitution.
Your Ladyship,
Ratification comes under which
Ratification
provision?
provision, this court would like to know, where is the provision in the Constitution?
Your Lordship,
Everything, if you are living upon them, that's it. Another thing, this ordinance making power of president as well as governor, it's not a routine, it is an exceptional power. Discretion does not mean arbitrariness. How do you justify that this discretion is not arbitrary? In the light of the question asked by ladies.
Your Lordship, the Council would like to take the help of the facts and circumstances that were prevalent in the current issue. The ordinance was passed due to the circumstances that were prevailing in the form of a multitude of security issues which were prevailing.
We know the circumstances. Tell us on law.
Oh.
We all are very well aware of all the facts. Tell us the legal proposition, on what basis you justify. Not on the factual basis, but the legal basis.
The discretionary parts of the Your Ladyship, in this amendment itself, we have included a provision where the governor has to justify his rationale to the president. Therefore, it is not arbitrary because the president is the titular head of a country, and he is assumed, like the first part of the Moot proposition also says that the constitution has not envisioned the president, or has been presumptuous that the president would ever take steps that are not in the interest of the country. Therefore, the fact that
Suppose they were not. I mean, factually, if the court is of the opinion and the people are of the opinion that this is not in the interest of the country, then can the court not quash such a decision?
Your Ladyship, in the unlikely event that this does happen, the Supreme Court has the right to intervene in the matter. However, the presumption shall never be amounted to be in a negative sense. It shall always be in the interest of the country. Therefore, having presumptions, negative presumptions about the intent of the president or even the governor doesn't suit the Constitution itself, which envisions them to make decisions for the benefit of the people.
So you have already, your government has not taken cognizance of public opinion, so where is the benefit of the people?
Your Lordship, the Council would like to clarify that the fact that the appointment of the lieutenant has to be ratified by the people is an example of how their will is being taken into consideration.
How it will be ratified? What is the
Mechanism.
mechanism to ratify?
Your
Under
Lordship,
which article will be filed the mechanism?
Your Lordship,
So you cannot simply say that it will be done.
There should be some law for that, there should be some procedure for that.
Your Lordship, the process with respect to the ratification of the Lieutenant Governor is not expressly mentioned in the Constitution because one is sui generis model and the facts are only limited to what the Council has said before this honorable court, subject to paragraph 32 of this new proposition.
You have to give the constitutional basis, not factual basis.
Your Lordship, there is no constitutional basis for the ratification of a Lieutenant
Then
Governor.
how can that be allowed?
Okay, it is the surrender to this person.
No, Your Lordship, the Council would just like to clarify that this, the appointment of a ratification of the appointment of a Lieutenant Governor is a hypothetication proposed by the Moot proposition. In reality, the Council submits that it cannot be done. There is no provision
Right.
on which the Council can rely upon to substantiate. That is why the Council is paying heavy reliance on the facts of the case.
All right, no problem.
Furthermore, the Council would like to make an argument by claiming that and lastly, the Council would make an attempt to establish that despite the basic structure being inapplicable, it is still not violated by the ordinance by substantiating that body has a sui generis model, and therefore we have taken the due consideration of the will of the people, which has been the primary contention of the opposing counsel. Your Ladyship, the Council would also like to highlight that my learned opposing counsels on page 27, paragraph 41 and line 4 of the written submissions have made a proposition claiming that the lawmaking power of the state legislature and the governor would be hampered by the passing of this ordinance. The Council would like to clarify that the legislative power of the governor and the legislative power of the state legislative assembly are two distinct powers and cannot be confused, and would just like to put forth this argument before the court. If the Council
See, legislative power of the governor, it includes power of the parliament also. A bill cannot become a law or act until and unless it is consented by. So how can you say there are two different powers?
no, Your Lordship, the Council is saying the legislative power of the governor, which extends only to making ordinances.
It is not. See, the house at state level, whether it is Vidhan Sabha or parliament, they consist of three organs.
Do Jordan has got a separate power, exercise his power than legislature? Is it independent power of legislature, or he acts as the head of the legislature, on an advice of the
He does act as the head of the legislature. However, the power to assent under Article 200 is Article 200.
You mean to say ordinance making power of governor is a power which he himself on his own take? Or Constitution says there shall be a governor, there shall be a president with council of ministers to aid and advise, and who will work on that.
Your Lordship, that
Satisfaction of president, satisfaction of governor is personal satisfaction.
Your Lordship, the Council is not denying the
How can you deny it? No.
Indeed, Your Lordship, however, it is not applicable to the present case because of the model of Guardia, which is completely different from what is there under normal circumstances.
And you should not test them. That's why your question comes from your argument only.
Indeed, Your Lordship. If Your Lordship is satisfied,
Okay.
the Council will proceed to the third issue. The Council would like to deal with the
Regarding the third issue, I have a question for you.
Indeed.
What is the distinction between the powers under 352 and 356? And I want you to carefully consider that 352 is proclamation, the procedure and the circumstances which can lead to a proclamation of emergency by the president. Now with regard to 356, it is the provision as to what happens when there is a failure of constitutional machinery in the state. So what is the distinction between the two? And how is a governor's power relevant in both these circumstances? Can you just throw some light on that?
Interior leadership, primarily.
And with some case law to substantiate what you're saying.
Your leadership, statutorily speaking, 352 allows the union, the president to proclaim an emergency in a part of a country or the entire country based on only 3 grounds, which are armed rebellion, external aggression, and war. However, under 356, like you rightly pointed out, it is only on the basis of the failure of a constitutional machinery. And the effect of both these emergencies is different. Under 356,
No, first tell us what is the difference in procedure. Where is the governor's role in 352 and where is the governor's role in 356? Does the governor play any role in 352?
no, your leadership. The governor does not play any role under 352.
Where does the role of governor come in?
Under 356, because he is the titular head of the state. So therefore, if there is a constitutional machinery is failing, the president would rely on the recommendation made by the governor as to if the constitutional machinery in the state is really failing or not.
So the way I'm understanding your argument is that 356 tells us that first the governor must come to a satisfaction that there is a internal disturbance.
Under Article 356,
Yes.
leadership.
Yes, I'm talking about 356 only. That the procedure is that the first the governor must come to a conclusion, not the legislature. The governor has to come to a conclusion that there is internal disturbance or there is a constitutional failure of machinery in the state and send a report to the president. And thereafter the rest of the procedure follows. Whereas in under 352, if the power has to be exercised by the president, he doesn't need any report from the governor. And then the core question arises whether the governor can send the report suo motu or he has to be bound by the aid and advice of the Council of Ministers. So is that the distinction between these two? Which is the case which has told us about these distinctions? Where have they been examined, maybe separately? Power under 352 must be examined separately in some case and 356 separately in another case.
Your leadership, the council is not sure of an answer, but would like to propose that I think it has happened in SR Gopal as well. I'm not sure of my answer.
So we have to first see under which provision the power is exercised. So first examine whether the power has been exercised under 352 or 356. And then examine the scope of the power.
Illegal leadership. However, the council would like to make a distinction between an emergency proclaimed under 352 and 356 on the effect that it has on the state legislature. For example, under 352, the state legislature is not suspended. However, the union gets the power to direct the state legislature according to what it deems fit in the interest of what is happening in that area. However, under 356, the state legislature stands suspended completely, which means that the president assumes the power to control what is happening in the state, with the exception of the courts, of course. However, in the present case, the proclamation has been made on the basis of Article 352, primarily lying on the basis of your leadership. Can I seek an extension? In the present case, we are relying on Article 352 not because of anything else, because of events that happened between a small period of time. They should not be construed as isolated events, instead should be construed as amalgamated events which happened in a short span of time, and the union is duty bound under Article 355 to do whatever and take any measures it deems fit in order to protect the interests and security of the country. And this emergency has primarily been proclaimed on that.
Which article of constitution impose such duty upon the union?
Article 355.
What did it say?
The Lordship of the Council would like to make a reference.
Hey, you give the key point.
That the union will take any measure it deems fit in order to protect the security of the country.
So therefore 356 comes into play. अगर कोई external उनको if he has got any, if you read 355, duty of union to protect states, then when the governor makes any complaint, when he is saying anything under 356, then the emergency comes into play. Either under Article 352 or 356 on the report of the governor.
Your Lordship, the facts are actually silent about whether the government has made such a report to the president.
Move for that. You have only 1 minute.
Your Lordship, lastly, the Council would like to put before this honorable report that the present abrogation of special status bringing the region under the central control is actually a proactive measure intended to mitigate the perceived risk of misuse of financial resources being exploited to perpetuate instability and insecurity within the region, especially by the
Well, if you have something to tell, then need not to read from the paper anything. It's not required. Come on, then.
Indeed, Your Lordship. And finally, Your Lordship, the Council is contending that the abrogation which is made by us is for the interest of the people, which will be dealt by my fellow council. However, I would just like to propose that we did this in order to ensure peace and stability in Puadia, which is a very integral part of India now. If Your Lordships are satisfied,
All right.
I would like to bring before my co-council. It has been an honor to be before the show. Thank you.
Council seeks permission to approach the dais.
Please.
Greetings to the bench. The present council will be dealing with issues 1 and 4. The council seeks permission to collectively refer to the bench as Your Lordship. Much obliged. So the first issue deals with, and the centre would like to contend the validity of the 107th constitutional amendment. What the 107th constitutional amendment did was it removed the bar placed.
Just go straight to the core. We
Okay.
know what 107 constitution.
Indeed, Your Ladyship.
We have a state level question.
Indeed, Your
All
Ladyship.
right. Let's come.
The council will be establishing this in a threefold manner.
Before that, we have a question. Okay. Your 107th amendment. Your 107th amendment. It is a colorful legislation, colorable legislation. Just justify it. Why we should not call it colorable legislation?
Your Lordship.
You are doing something when the matter is already on, and you are going to amend the case without waiting for that.
Your Lordship, the council would like to clarify that the present amendment was actually made in furtherance of justice so that the decision made in the ongoing case could be given finality as the contentions of the petitioner rest on the Treaty of Magna as clarified by para number 54 and 63 of the Moot proposition, and the jurisdiction of the Supreme Court is barred under Article 363 to look into the treaty, thus in furtherance of justice, and so that after this case is decided by this honorable bench, the petitioners cannot contend the finality that
The question which has been posed by a learned judge is not with regard to what was the intention behind the legislation. The question that is posed is that under which is the case law which tells you that a colorable piece of legislation can be questioned, and what are the factors which will determine a colorable piece of legislation? Drive straight to that point.
Your Ladyship, this would not be a colorable piece of
No, we
legislation.
are not asking you to justify. We are asking you that which is the case law which the Supreme Court may have decided earlier on, which defines what a colorable piece of legislation is. And secondly, what are the parameters which tell us what a colorable piece of legislation.
Your Ladyship, the council would not be aware of the particular case law regarding colorable piece of legislation because the council would like to contend that there are two constitutional provisions which actually enable the parliament to make the present amendment, which is Article 138 and entry number 77 of the Union List, which clearly says that the jurisdiction and powers of the Supreme Court to be amended or enlarged, as Article 138 would say, is the power of the parliament. Thus, it not being a colorable piece of legislation, the council is not aware of the case law which would deal with colorable piece of legislation. Since the council is contending that it isn't a colorable piece of legislation by these two constitutionally laid down provisions which empower the parliament to enlarge the Supreme Supreme Court's jurisdiction under Article 138 and to deal with the powers and jurisdiction of the Supreme Court under entry number 77 of the Union List. Council seeks permission to proceed.
No, I have another question. Would you think that changing the scope of jurisdiction of Supreme Court would not be an aspect of basic structure? Would our founding fathers not have envisaged what would be the length and breadth of the Supreme Court while making the Constitution, and any change to what was made in the original text of the Constitution would violate the basic structure?
Your Ladyship, the Council would like to refer to two significant judgments in this regard. Article 363 is not a part of the basic structure doctrine. It was held in Madhav Rao Scindia judgment, which was further reiterated in the Raghunath Rao versus Union of India judgment, as the present bar was placed so that the treaties which have been made before the Constitution, especially at that present moment, the rights and privileges under Article 362, which has now been repealed, still being very much present, thus the bar was placed. However, since we want that this issue to be finally decided in the interest of justice and the citizens of Kuwadia, we would like to remove this bar so that this honorable court can look into the intentions of the petitioner, and thus we do not want this issue to come before the court again, and thus though we would like to contend that the treaty has not been violated, however,
So why was an amendment needed? Would a reference be made by the President under copy?
indeed, Your Ladyship, Article 363 does refer to the advisory jurisdiction under Article 143. However, that advisory opinion is not binding and is just an opinion. Thus, to give binding value to whatever the Supreme Court would deem to be the interpretation of Treaty of Magna and the contentions of petitioner, the Council has pleaded that the present bar under 363 shall be removed.
If we were to follow your argument, then whenever the Parliament feels that we want Supreme Court to decide a particular issue, it would be free to amend the Constitution. Is that what you are contending?
Your Ladyship, it would not be free to amend the jurisdiction. However, here we're just enlarging a part which will no longer violate the principles as 362 is already repealed, and this present bar is acting as an impediment right now in the present case, which will further question the interest of justice and the finality which this court would give in the present decision, which is actually a grave concern, since Kuwadi's integration into Indiana in the truest sense is a matter of great significance to the not just the citizens of Kuwadia, but the country as a whole in this country. Furthermore, the Council would like to bring to this court's attention that the petitioners claim that the procedure laid down under Article 368 has been violated as the state legislature's consent has not been taken. However, we would like to bring you to para number 63 of the Moot proposition, which would deem that this present amendment was brought in after the Reorganization Act had already been taking place. Thus, the union territory had already been established, and there was no state legislature to give this recommendation to. Thus, we would like to establish that the procedure under Article 368 to bring in the present amendment has not been violated. Furthermore,
No, Article 368 specifically provides a procedure, and all the subjects have been divided into three categories. So, in which category it falls?
Your Lordship, we are trying to establish that they pointed out that under the second.
No, you tell me. You tell to this court in which category it falls.
The category of.
There are one category one. They are amended with simple majority.
Indeed, Your Lordship. So
In which category it falls?
Your Lordship, the facts are silent about the specific category of the 107th
No,
Amendment.
but it can be made out. Whether it is silent, but it can be made out through this 21-page proposition.
Your Lordship, since there are two categories which are mentioned under Article 368 and one of the categories not being mentioned, so definitely this is not an amendment made by simple majority.
There are three categories.
Yes, Your Lordship.
Okay.
By simple majority, by special majority, and the special majority by ratification. The latter two are mentioned under 368. However, the former is mentioned by the phrase Parliament may by law through various provisions. Now, since this present amendment does not speak to it, we would like to interpret it as being under Article 368, thus falling within the latter two categories. However, amongst them, which category does it fall under would not be established. However, we would still like to establish that the procedure laid down as claimed by the petitioners would not stand true because the state legislature was not present at this point, as it had already been converted into a union territory. The Council seeks permission to proceed.
Not yet. But what is the procedure of the category in which you wanted to clarify?
Your Lordship, the Council is trying to put forth that since there are two categories,
Is it in third category?
the third category being special majority by ratification or...
What it says?
Your Lordship, the Council...
What third category says provide for?
Your Lordship, there is simple majority, special majority, and special majority by ratification.
What is special majority?
Special majority is 2/3 rather than half.
No. It is like clearly mentioned in this case. And you, no, just tell me. What is special majority?
Special majority is
We want to know your understanding about this special majority.
it's 50% of the people present and voting, and then it has to be ratified by 2/3 of the members of the parliament.
And now we read 368. Majority of the house plus 2/3 member present and voting.
The opposite.
You are forgetting majority of house is not discussion.
Think of it numerically only. What will be special? What will be larger?
Yeah, but we're trying to highlight that the fact that this procedure was not followed is not mentioned in the facts that this procedure was followed. The fact that the legislature's consent or recommendation which is necessary was not taken can be established because the state legislature of Guardia wasn't there, because it has now been converted into a union territory by the order, and subsequently the 107th amendment was brought forward. The Council would also like to establish that the procedural law or this jurisdictional, we wanted to bring forth this present jurisdictional amendment so that the procedural law, the procedural jurisdiction does not act as an impediment to the cause of justice as has been held in State of Punjab versus Shamlal Burari. The Council would like to now seek permission to move on to the fourth issue regarding abrogation of the special status. Much obliged, Your Lordship. The Council would like to establish the constitutional sustainability of the abrogation of special status of Guardia in a multifold manner. Primarily, the Council would like to establish how the present provision was temporary in nature, thus giving the Parliament to abrogate it.
Before that, you establish from where you get authority to act upon in this manner. Which act or constitution provide, which article of constitution provide you power for abrogation of the...
Your Lordship, the clause itself has a self-destructive clause under the 7th clause of Article 371A, as is present in the Annexure 2, which lays down that the Parliament may by law abrogate this provision by taking the recommendation of the state legislature. However, the Council is presently establishing that since this article is placed under Part 21 of the Constitution, the marginal heading of which reads temporary, transitional and special provisions, and the self-destructive clause which is present under clause 7 of Article 371A, the Parliament had power to abrogate the special provision as it was not permanent but rather temporary in nature.
The question that we have, which has vexed all of us, is that when you're abrogating the rights, we are not talking about the language and the letter of the law. When we are abrogating the rights which are given under the temporary provision by way of a constitutional provision, how can that be abrogated by a statutory provision, which is much lower in significance than a statutory provision?
Your Ladyship,
Is it not necessary for us to amend the Constitution and not use a statutory provision to take away the rights? Now we are talking about the rights vested in the legislature and the people of that particular state.
Indeed, Your Ladyship, the Council would now like to establish what was special about 371A, that was their special status, and how abrogating that also does not leave. These measures will indicate that presently the Council would like to just seek an extension to wrap up arguments and to answer this question.
One more question there. So, in this context, again the question comes, will of the people. It is for the state or for union territory under this circumstance.
Your Lordship, the will of the people.
You are arguing on will of the people.
Indeed, Your Lordship.
Your arguments are revolving around it.
Indeed, Your Lordship. The Council would like to clarify that the 7th Constitution, the 7th clause of this article is actually in violation of the Constitution itself, and thus by the present amendment, we are also trying to rectify the past mistakes, as the will of people of Guardia cannot supersede the will of people of Indiana. Now, if we are in a representative democracy, if the Parliament is the representative of the people of Indiana,
You are doing excessive.
Your Lordship,
There are two different type of people in this country. If you take it in the same territory.
no, Your Lordship, and thus the seventh clause
We are
does
people of Odia, we are people of the country. Is it different?
it shouldn't be, is what the council would like to return, Your Lordship. If Your
Thank you.
Lordship is satisfied, the council would like to move on to the prayer.
Thank you very much.
Would you proceed
Come
with
on,
the prayer?
prayer.
Wherefore, it is humbly prayed before this Honorable Supreme Court of Indiana that in light of the issues raised, arguments advanced, and authorities cited, may this Honorable Court be pleased to declare the ordinance promulgated by the President as not arbitrary, hold the national emergency as constitutionally tenable, declare the state of Kuwadia Reorganization Order 2023, which brought into effect the order to abrogate the special status of Kuwadia under Article 371AA as intra-wise to the Constitution, hold that the 107th constitutional amendment passed by the Union was valid and or pass any such order, direction or relief as the court may deem fit in order to uphold the principles of justice, equity and good conscience, and for this act of kindness the respondents shall forever humbly pray.
Yes.
It was an honor to have
Statement reserved.
You have liberty.
Do you want to say anything?
Liberty, otherwise you will be marked for that.
Would you like to add something?
Claim it, otherwise you will go for that.
Yes.
President rules on this.
So for issue 3, first of all, internal disturbance as a ground has not been
Slowly.
internal disturbance as a ground has not been justified in the present case. The case of Gujarat, Mazdoor Sabha and another versus State of Gujarat has been given by the respondent side, but it has to be seen that it was interpreted or comprehended with the Factories Provision Act, which gave internal disturbances of ground under factories of the factory provisions of the Factories Act.
You claim everything, we are not going to ask any question, they will reply.
So, also Article 19 suspension under Article 358 as rightly pointed out by the laws that it did not contain the recitals for such an effect, and also it was beyond the scope of statute because no ground existed. Another thing is that modified nature has also been not been justified. In fourth issue, Parliament may by law give effect to supplementary, not abrogate. The language is very clear in Article 371A, Your Lordship. Also, the separatist tendencies is basically not justified. It's not a fact in the court law, and how does it arise is not been justified. Marginal note can only be a guide and cannot be the sole interpretation for the Constitution. Recommendation of the state legislature suffers from democratic deficit and also not been justified again. Order under Article 3, how it can be passed. Under Article 3, only bills and act may be passed. How an order has been passed is not justified. Also, under issue 1, para 54 that the petitioners mentions that the right of petitioners were contended on the basis of Treaty of Magna. Also, enlargement through amendment has to be made under Article 368 of the Constitution. The Act of States had been made justiciable in the present case. Ratification of the not only of the legislative assembly was required, but half of the state legislature was required there. For the second issue, aid and advice of the minister was repealed when there was no imposition of emergency. Direct representation cannot be replaced by indirect representation. There was no check on the. Yes. Also, the president, by communicating his rationale to the president, there is no check on the arbitrary exercise of power limited in government there. Also, ordinance by the respondents has been mentioned as an amendment in their speech. Ordinance, that is it, Your Lordship.
Thank you very much.
Thank you. Council seeks permission to approach the dais.
Yes, you are right now. Briefly.
We would like to just quickly reply to all of their rebuttals. Firstly, the council would like to establish established that we have not abrogated the article under clause 5 of the article, but clause 7 of the article, which gives us the power to do so. Furthermore, the separationist tendencies can be easily identified by the protests made for the citizenship rights of the people who have infiltrated into the country, which are from Palestine and Gaza. Furthermore, the marginal heading has to be, and as the case that I mentioned, it has to be, and also the Uttam Das Shila judgment also clearly brings down that the marginal heading does give you a right to go into the mind of the legislature and the legislative intent. Thus, to identify what was the nature of provisions under Part 21, you would have to ultimately go through the marginal heading, which includes the word temporary under Article 21. Furthermore, the council for the petitioner again tried to establish and point out that the state legislature's recommendation was not taken while passing the 107th Amendment. But to clarify, as was done earlier also, this amendment was passed after the reorganization order, thus there was no state legislature, it was a union territory. Lastly, the council pointed out that the ordinance was passed when there was no emergency. The council would just like to highlight that the ordinance does not require the proclamation of an emergency, but the parliament not being